Well, thank you very much. I will call the next case then. This is People versus Juan Martinez. This is a 15-minute mini oral argument on the application. Mr. Gonzales, you will start, and you may reserve some of your 15 minutes for rebuttal if you can. That's up to you. And you may proceed.
Thank you, Your Honor. May it please the court, Attorney Abraham Gonzales here on behalf of defendant appellate, appearing as co-counsel with Attorney John Moritz on behalf of Juan Martinez III. Thank you for allowing our issue to be heard in this forum. We appreciate your time. I'm sure the court is fully aware of the legal and procedural background here. So I'll just take a brief moment to highlight some of the important issues on behalf of Mr. Martinez. First and foremost, regarding admissibility, as the court is aware, the Court of Appeals presumed error and started their analysis regarding the prejudicial effect. I believe that, as stated by the record, defendant appellant's original trial court attorney was intending to introduce this threat of false allegation in regards to attacking the credibility of the declarant. So I don't believe it requires a hearsay analysis to even get over the initial hump of admissibility. But if the court were to look at it through a hearsay lens, I believe that 8033 regarding then existing mental, emotional, physical condition would allow its admission. So I'm not really sure if we need to even get into the hearsay analysis. I'm open to any questions regarding the first prong of admissibility. Some of the issues regarding the prejudicial effect rely heavily on the practical implications from the admissibility issue. We're talking about a threat of a false allegation that is extremely similar to the allegation made in this case, where we have a declarant stating that they are willing to commit a criminal act and filing a false police report or lying about a criminal sexual conduct to prevent her mother from being involved with someone else, in that case being her biological father. I understand that there's some differences as pointed out by the people regarding that it's two different people, the time frame regarding about when she knew whether or not Mr. Martinez would be moving back into the house or not. I don't believe that those carry as much weight as the appellee would argue. I think the importance of the threat of the allegation has so much prejudicial impact because it shows the willingness to fabricate, the knowledge of the consequences of that fabrication, what it will achieve to fabricate, and even considering the strength of those allegations. I would ask the justices if they have any questions.
Thank you, Mr. Gonzales. I'll start with Justice Viviano.
I do not have any questions. Thank you.
Justice Bernstein.
No questions at this time. Thank you.
Justice Clement.
No questions.
Justice Cavanagh.
None for me.
Justice Welch.
I actually have one. Thank you, Mr. Gonzales. I do have just a quick question for you. Is it a fair characterization to say you're interested in this evidence to attack the credibility of the complainant and not as substantive evidence? Is that correct?
I believe that our argument is that that is one way to get the evidence in through only attacking credibility. And I believe that that's our strongest argument for admissibility. But I do believe it also could come on substantively under 8033. But I believe we would be arguing that it's admissible under the issue of attacking credibility.
Justice Welch, any additional questions?
No additional questions.
Mr. Gonzales, I have a question. The prejudice question is always hard. It's especially hard when we're trying to figure out what a jury would have thought about evidence it didn't hear. The particular evidence here does seem like evidence that a jury would be interested in, but in the previous, I mean, the evidence was not that the complaining witness did in fact make a false allegation in the previous instance. It was that she threatened to and did not. Now, I'm not endorsing the Court of Appeals majority view that makes her more credible, but it does make it complicated for arguing prejudice for your client. Can you tell me why it would have made a difference in the outcome of the case?
Well, as the court is aware of the record, there's not any other evidence, generally speaking, physical or bad statements from Mr. Martinez. But specifically to your question, I think it shows a couple of different things. One, it shows that she has knowledge of what a false allegation would accomplish. It would accomplish that this person would be criminally prosecuted. It would accomplish putting up a definitive wall between Mr. Martinez and her mother. It shows that she knows what consequences come from a false allegation. And she is able to accomplish that, her goals of keeping her mother's suitor away from her. So it shows an intent and a plan here that she is fully aware what a false allegation will do, and she's willing to carry it out. Maybe she didn't carry it out against her father in the original threat of false allegation, but it shows she knows what it does and what she can do with that false allegation. So I believe that is where the bulk of the prejudicial effect would come from.
Thank you. Justice Zara.
No questions, thank you.
Any additional questions for Mr. Gonzales? Any additional points you would like to make before reserving your rebuttal time, Mr. Gonzales?
At this point, Your Honor, I would just reserve time for rebuttal.
You may.
Thank you.
Absolutely. Mr. Sanford,
Morning.
you may proceed.
Thank you. So I get how, in fact, Justice McCormack, you said that the jury might seem to be interested in this type of information. And I certainly get that at a superficial level. I think defense is arguing here that the 2014 statements are so similar to the 2017 accusations that the 2014 statements should come in. But I would urge you to reject those arguments because of two things, and those are the facts and the law, two little things. I think we've already kind of hit on some of the facts that separate the two statements. 2014, the victim was a 14-year-old middle schooler. 2017, 3 years later, she was a junior in high school. I also think it's important that the 2014 allegations, or statement, I should say, concern the father, and that's an emotionally fraught relationship. Whereas in 2017, as the victim stated, the guy was just my mom's boyfriend. The two important distinctions, and again, I think Justice McCormack, you hit on this, was that the victim never followed through. In 2014, she never went ahead and accused her father of any touching. And yet another factor I think that's important factually is that in 2014, the victim made that threat only after she found out that her dad might be moving back in. And in 2017, the victim made her accusations a month before she found out that the defendant might be moving in. So her intent in making those allegations factually a month before wouldn't have went into, I want to keep him out of the house. So those facts, of course, have consequences. I think it's relatively clear, of course, on the prosecutor, that this is hearsay. And I am happy to answer questions on that. I would just point out that the case of People versus Melvin at 70 Mishap, DeRucia at 109 Mishap, similar circumstances, a similar statement. Both courts agree that, yeah, this is hearsay. This bounces us then, of course, into, well, does 803 apply, state of mind? And I would say this. In People versus White, 401 Mish at 482, the predecessor court said that state of mind is only something that's relevant if it's concerning something that's in issue, right? Something that's in issue. And I find it hard to see where the victim's intent in 2014 is really in issue in 2017. The court went on, in issue kind of means, well, does it relate to any elements of the crime? or the defense? And here I think that answer is clearly no. Two entirely different situations, two entirely different people, 3 years apart. If it doesn't fit in under 8033, well, okay, is it admissible for impeachment purposes? And then we go to 608B, and I would note simply this, and this is a distinction that the Court of Appeals also noted. If I say that I'm making a threat to lie, if this happens, I'll lie, that's not dishonest. In fact, that might be the height of honesty. I'm telling you right up front that I'm going to lie. So that in and of itself is not a lie. Hence, it doesn't go to truthfulness or untruthfulness. So I think because it's not a lie, it's in essence a truth, I don't believe that the evidence would fit in under 608B either. Hence, leave should not be granted.
Thank you very much. Justice Viviano.
Well, counsel, I guess to say I don't find it that persuasive that this is hearsay and that it wouldn't be properly admitted under 608. And I guess in terms of its relevance in the case and to the jury, I think the harder question is whether, since it's not evidence of a prior false allegation, but instead evidence of the fact that the threat to make such an allegation, whether its exclusion in this case would be harmless. And I guess my question is, just looking at it from that perspective, it seems to me that the jury would have been interested to know that this young person was sort of wise in the ways of the world. In other words, that she was aware at her young age of the devastating effects of an allegation like this. Not something maybe that every young person thinks about. What's your response to that?
Well, I think the Court of Appeals got it essentially right when they said, all right, if that statement were to come in, then the assistant prosecutor could have brought up, well, look, again, this statement wasn't
I know
made.
there are things that you could say and that you would say and that you've said in your brief, but my point is, I get that she didn't follow through, and this time the threat wasn't made exactly the same way. But it's still a pretty peculiar thing for a young person to say, and to know that these types of allegations can be weaponized to get what you want. Why isn't her sort of consciousness of that sort of reality something that would move the jury here in terms of whether she would make it again to get what she wants?
All I can respond to that, sir, is that the dissimilarities between the two instances, the 2014, the 2017, I think the prejudicial value or the problems with that would outweigh any probative value of the statement. And I think that's a determination for the court to decide, right? Juries always want more information, and of course they'd be interested in it. But I think it's up to the court to decide, well, whoa, wait a minute. That might have some marginal relevance here, but deep down it's too prejudicial. Justice, I don't know if you wanted me to discuss, you mentioned something about you weren't convinced or whatever on the hearsay argument.
I don't need you. To me, I think the more interesting issue in the case is the harmlessness, and that's
Okay.
why I tried to bring your focus there. But thank you, counsel.
Justice Bernstein.
Counsel, good morning and Happy New Year. And I'm going to kind of take you back to the prejudice prong and the discussion that we were having, because I just think it's so important. And I'm just going to follow up with Justice Viviano's question. And I guess if you could alleviate my concern, because this is where my concern arises, ultimately this entire case comes down to credibility. There's not much other evidence other than the credibility. And,
True.
I know you addressed the Chief's comments in terms of the statements, and I know you addressed Justice Viviano's comments, but it's one of those situations where, if you don't have too much other evidence as in result of this, and the case really does come down to a credibility determination, help me assuage my concerns that, that this is the kind of evidence that if a jury were to have heard, would have had a tremendous impact in the defendant's favor, would it not? Help to assuage my concern that, evidence like this not being permitted can't just simply be seen as harmless.
Boy, I can only reiterate what I said, I think, previously. Evidence would come in to show, obviously, that she didn't follow through with the statement. In fact, she was totally candid.
I understand.
And again, the prejudice of that, that's why we have 403, right? Because some evidence might be too probative, if you will. I mean, again, I think the statements in 2014 are so dissimilar, circumstantial wise, to the 2017 statements that there's no real comparison. And a jury might think that with some loose thinking, and they would put too much weight on that. And I think that's the court's role to determine that that's not admissible, and the jury shouldn't be able to consider that.
Okay, counsel, thank you so much. And thank you for answering the question twice.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
No questions.
Justice Welch.
No questions.
Justice Zara.
Questions, thank you.
Does anybody have any additional follow-up questions for Mr. Sanford? Mr. Sanford, you have a few minutes. Do you have anything else you want for us to hear?
I guess not. I don't want to waste your time. I'm happy to talk about why I believe it's hearsay, why it doesn't fit under the 803.3 exception. Other than that, I'm good. Thanks.
Thank you very much. Mr. Gonzales, you have some rebuttal time. I believe the clock says 8:50, but I believe you wanted to reserve 5 minutes. So you have 5 minutes of rebuttal time, and you may begin.
Thank you, Your Honor. I will not belabor any points regarding admissibility, but regarding the prejudice, I think the justices have touched on all the important points. This was a case of he said, she said. There was entirely no other evidence regarding anything else, which really heightens the weight of this issue. As Mr. Sanford stated, this is extremely probative. This evidence that we're dealing with is extremely probative. It goes to some type of knowledge that these false allegations are able to accomplish. And I think that really carries a lot of weight in this case. The other thing that I wanted to address very briefly is the similarities that Mr. Sanford would put forth. I see it in the exact opposite, that these are strikingly similar. I'm not really sure what else could be more similar regarding the nature of these threats of false allegations. I don't think it's as narrow as saying that the declarant was attempting only to keep Mr. Martinez out of the house. I believe that is one of the aspects that the declarant was attempting to accomplish. But I think it's a lot broader than that. There are other things that I believe that was being attempted to accomplish with the threat of false allegation, keeping him out of the house, keeping him out of their life, making sure that he never came back to be in this relationship with her mother. So I believe that them to be extremely similar, the prior threat of false allegation as well as the allegation made in this case. I believe that the threat in itself is weighty enough to show prejudice in this case, Your Honors. If you have any questions for me, I'm willing to answer.
Thank you very much. Are there any additional questions for Mr. Gonzales? Hearing none, I want to thank you both for your presentations. This case will be submitted. Thank you.